Okay, thank you for everybody coming to the webinar and attending here. We're very thankful to have Catherine, Tracey, and Steve Van Stempvoort from Miller Johnson here to help us talk about the legal issues surrounding COVID-19, what the new laws mean to you and your business, everything from the employment realm to what is and isn't allowable. I know Steve will be able to talk a little bit about what that executive order means, specifically towards you and your business. And Catherine is very good with the legal side of things on your employment issues. So my name is Troy Baker. I am the director of the Better Business Bureau Educational Foundation. Thank you for coming and joining us. We're going to try to do this in an hour. So we will get through this. We are going to take questions. Everybody is on mute. If you have a question, please enter it, type it into the questions section. We will get to questions at the end. Hopefully, Catherine and Steve will be able to answer them as part of the presentation, but anything that isn't answered, we are happy to do and get to here at the end. We're going to leave some time and hopefully get this done in an hour and get you on with the rest of your day. So thank you again for coming. I will hand off to Catherine and Steve now.
Well, good morning, everyone. This is Steve Van Stempvoort. As Troy mentioned, I'm a partner at Miller Johnson. I'm in the litigation section, and I'm here with Cathy. Cathy, you want to introduce yourself as well?
Yep, my name is Cathy Tracey. I'm a partner in the labor and employment section.
So obviously, Cathy is the expert on the employment stuff. I'm the litigator, so I'll be talking a little bit about the executive order. But I just want to, again, thank you for having us. Thank you for coming out, making the effort to join us in this webinar. Hopefully, we'll get to a bunch of the questions. I know that this area has been changing every day, almost, and so we're going to try to talk about some of the most recent developments. But there are probably going to be some things that we don't cover completely in our presentation here. And so if you have questions, obviously we'll try to take them at the end. And if we can't get to them, we'll work with Troy to address anything that's hanging over at the end. As far as what we're going to be doing today, I'm going to do a very brief introduction here on the executive order, just kind of talking a little bit about some of the things that are most pressing right now, some of the trends we've seen, basic overview of what's allowed and what's not allowed, and specifically hoping to help you be able to communicate that to your employees, because it's very helpful. And then Cathy is going to spend the bulk of the time talking about employment questions, particularly unemployment. We're going to review some eligibility questions and some other challenges that are being presented by the unemployment rules and benefits that have been recently enacted. And then she'll also talk about the Family First Coronavirus Response Act. Of course, that's a significant development in this coronavirus response, and so she will cover those issues as well. So let's talk about the executive order first of all. So just as you may know, the executive order currently expires next week, April 13 at midnight. However, the governor has asked the legislature to extend the disaster declaration. She requested 70 days, but my understanding is that the Michigan legislature is likely to extend that by 23 days only, extend it to May 1. So that is the most likely scenario right now, and we anticipate that the executive order will also be extended consistent with that extension of the disaster declaration. We're not sure, of course, whether it will be revised or whether it will look exactly like it does now. It would be nice in many ways if it was more tailored than what it is now, but we'll have to see. So I just wanted to put that on your radar, that there may be some changes coming, and hopefully we'll see within the next couple of days what happens there. Just in terms of the executive order itself, many of you I know have already thought about whether you guys are allowed to keep on operating, you know, the sorts of things that you folks, that your businesses can do, which workers are critical infrastructure. But I do want to just run over it quickly because I think it's really important that that companies, employers are are able to communicate to their employees about why their company needs to keep operating and why their employees need to keep coming to work, or conversely, why your company cannot keep operating, why they can't keep coming to work. So a huge part of this that we've seen on the enforcement end has been driven by consumers and others calling into the hotlines for the attorney generals, the local prosecutors, and indicating that certain companies are operating, and a lot of your ability to explain exactly what you're doing and communicate to your employees, and then potentially to the public about why you are continuing to operate will go a long way in addressing some of those issues on the front end. Now, under the executive order, as you may recall, you're allowed to keep, every company is allowed to keep employees on the physical premises for minimum business operations, but that really only involves maintaining the security of the premises, maintaining inventory. That really doesn't allow you to keep people there to run the business or keep it open to the public. And there have been some issues with folks who have kept too many people on premises, and that has generated complaints. And so that's something that you want to make sure that you are careful about. As far as critical infrastructure workers, this is obviously the bigger section. You can keep your operations open with respect to workers who are doing critical infrastructure. Those sectors are defined in the executive order. There are also FAQs on the governor's website. Admittedly, those FAQs change almost every day, and sometimes they change inconsistently with each other. So that's a very difficult thing to keep straight, and but those are supposed to be helpful. If you are operating in a gray area, obviously you want to check those FAQs. You want to see if you can get legal advice if you are concerned about whether what you're doing actually does fall within critical infrastructure. You also have to designate your workers as critical infrastructure workers. You have to do that in writing. You want to make sure that you designate only the ones that are necessary to fulfill your critical operations. We haven't seen very much enforcement about the scope or the number of workers that have been designated. So keep that in mind. However, that is what the executive order does require. It requires you to kind of trim up your workforce to those who are necessary to be to fulfill your critical infrastructure obligations. You're also allowed to designate any suppliers or service providers that are necessary for you to continue your critical infrastructure obligations. So if you've got subcontractors, if you have certain suppliers, if you're a manufacturer and you have certain suppliers that you need to continue supplying your product, you want to make those designations. Again, those have to be in writing. And again, you don't want to wildly over designate there. Now, we haven't seen much enforcement related to that. If there is somebody who has a critical infrastructure designation from a customer, that seems to be to generally suffice if there are questions. So to the extent that you have a supplier that you do want to keep open, make sure that you designate them in writing and provide that to them so that they can present that if they do get questions. And then, just a kind of couple specific things about some considerations you should think about when making these critical infrastructure designations. One thing, if you have been designated as a critical infrastructure supplier to some other customer, to some other business, you may have to consider whether you have to keep producing your products, or whether you have to keep on producing the supplies. Because if you have been designated as somebody who is allowed to remain open under the executive order, then you may not be able to rely on certain contract defenses to breach. So, for instance, if the governor's order prohibited your company from being able to operate, then ordinarily you could defend yourself against a breach of contract action by relying on a force majeure or impossibility as a contract defense. However, if you have received a designation as a critical infrastructure supplier, that defense may no longer be available to you, and so you have to consider, whether whether you need to keep on operating to produce whatever supplies that you've been designated as a critical infrastructure supplier to, because otherwise you may have some contract issues down the road. And again, I'm just going over these very at a kind of 1,000-foot level. And so if you have questions about any of that, please bring them up in the Q&A or contact me afterwards. I'm happy to discuss those. I just wanted to flag that for you. As far as enforcement goes, I'll just spend like a minute or two here on some trends we've seen. Remember there are penalties under the executive order, and then also under the Michigan Department of Health and Human Services order that was issued last week. Those under the executive order, it's a $500 fine or a misdemeanor. Under the DHHS order, it's a $1,000 fine, and there are also potential licensing implications. So that if you're a licensed business, they may refer you to the appropriate licensing agency. Now, remember that under the executive order, it needs to be a quote, willful violation of the executive order before the penalty is incurred. So that will give you a lot of cover in terms of, very likely, and this is what we've seen, is that local law enforcement are the ones who are being tasked with responding to complaints and enforcing these things. It's not the Attorney General in the first instance. Prosecution generally is a remedy of last resort. Law enforcement has a lot of other things that it prioritizes, especially now, and they want to limit public contact anyway. So typically what we've seen is a warning letter. Somebody may show up and, the law enforcement may show up in response to a complaint and ask what's going on. You may get a warning letter from local law enforcement or local prosecutor. Maybe you get a warning letter from the Attorney General's office. That's typically reserved for, kind of larger entities. But remember, the penalty only applies if there's a willful violation. So they may say, look, what's going on here? And what we've advised our clients to do, and has been very helpful, is to document your decision making. So we've had law enforcement show up at clients in response to a complaint, and our clients have been able to come out with documents that support their decision to keep operating. One of the things that we've done, if you're operating in a bit of a gray area, you're not sure if you really are critical infrastructure or whether your workers are providing critical infrastructure work, what we've done is we've prepared opinion letters for clients that go through the analysis and explain why you are critical infrastructure work. Those have been very helpful in when law enforcement shows up, then our clients have been able to explain, well, here's what I did, here's the analysis, here's why I fall within this particular critical infrastructure. And then obviously everything else should be in writing. There are designations of who is critical and who is not of your employees. That should be something that you're able to point to and kind of give a rationale for why you've made the decisions that you have. And then to the extent that there are employee and transportation issues, what we've done is we've given many of our clients notices that they can give to their employees that say, you've been designated critical infrastructure worker, and here's an authorization that allows you to travel to and from work and or to customers for work purposes. Now, those documents are not legally required under the executive order. However, we found that it's very helpful. It gives employees a lot of peace of mind. Number one, to be communicated, to receive the communication about why they are continuing to work, why their work is necessary and important, even at these turbulent times. And it also gives employees peace of mind about traveling to and from work. There have been a lot of rumors about folks being pulled over by law enforcement and asked where they're going. Those incidences have really diminished, but even so, it really does help. We found that it's really helped to have employees have a little bit more security about traveling to work and traveling for work-related purposes if they do have a sheaf of documents that they can pull out and present to anybody who has questions. So that is a very very quick overview of what's going on, where we have seen enforcement actions. And I'm happy to talk about any of that later on in the Q&A or afterwards. But I'm going to turn it over now to Cathy because I know much of what we want to talk about today is employment law related, and she is the expert there. So Cathy, I'm going to turn it over to you.
Sounds good. Thanks, Steve. similar to Steve, I'm going to have to do kind of a 10,000-foot view approach on all this because, as you might imagine, there are just hordes of employment-related issues that affect employers that are coming out of all of this. So I sort of broke it down into some of the most common questions that I've been getting. First, we'll kind of start talking about unemployment. The primary one is, are my employees eligible for unemployment? The governor did issue a couple of executive orders where she broadened eligibility for state unemployment for workers who are impacted by certain specific COVID-19 related reasons. So for employees who are in self-isolation or self-quarantine because they're immunocompromised and they're at elevated risk to contract COVID or would have more health problems if they did, they would be eligible for unemployment during that period. For employees who are displaying symptoms of COVID-19, which as of last week, Michigan is defining as fever, a cough, or shortness of breath. I've attached here on these slides the CDC guidance on symptoms, which is a little more clear, but as I'll mention a little later, Michigan has issued its own guidance on what it deems are symptoms of COVID-19. Another area of eligibility is for employees who have had contact within the last 14 days with somebody who has a confirmed diagnosis of COVID-19 or who needs to care for somebody with a confirmed diagnosis of COVID-19. I underline confirmed because it doesn't deal with suspected cases or people who are in quarantine or people who are showing symptoms. It has to be a confirmed case, which still with the way that testing is going, there aren't as many of those as suspected ones. Finally, it enables people to take unemployment who have a family care responsibility as a result of a government directive. So all of those folks who are caring for their young children because school or childcare is closed are eligible for unemployment if they cannot work. The old typical unemployment bases also still apply. So, if you lay people off because of business reasons or put people on an unpaid leave of absence because work has slowed down, then they're going to get unemployment as well, no question. And then under this new executive order, the way it is supposed to work is that if the employer lays off or places employees on an unpaid leave of absence for COVID-related reasons or because of the impact that all of this has had on their businesses, the employer's account is not supposed to be charged for benefits. So one thing that we've been hearing is that sometimes those charges are still showing up. So our recommendation is to make sure you look at what you're receiving from the unemployment agency, and if there are charges on your account that are related to layoffs or leaves of absence for COVID-related reasons or business slowdowns, then we should contest that right away. So where should you tell your employees to go? I have a little screenshot here of the website and phone number that you can call or direct them to call in order to file for unemployment. One thing you should let them know, which they may have read in the news, is that there have been some extreme challenges with getting those unemployment benefits processed. The unemployment agency has been absolutely overwhelmed with the number of claims that are pouring in, and frankly, they're just not staffed or set up to process them. I think this was completely unforeseen, and I mean, one of my partners who does a ton of work with unemployment said there's like literally 20 people in the state who are working on processing these claims. And so the system is just completely overwhelmed. You may have also heard that recently the whole computer system has shut down on numerous occasions. What we are telling people is that if you want to have your claim processed with the least likelihood of the computers failing or you having to wait for a long time, do it at off hours. So between 8 p.m., 8 a.m. If you are if the employee is a late nighter and they can call at 2 a.m., 3 a.m., that would be even better. In advance of this webinar, many of the questions that we saw had to do with whether under the new CARES Act, whether any of you business owners or self-employed folks or independent contractors may be eligible for unemployment benefits. And the answer is maybe yes. So what the CARES Act did is three primary things. It provided state unemployment benefits to people who normally can't receive unemployment benefits. It also provided an additional $600 a week in addition to state unemployment benefits for pretty much everyone who's entitled to benefits. And then it also provides an additional 13 weeks of benefits once individuals had exhausted their state unemployment benefits. So let's kind of run through those quickly here. The first question is, how does this work with people who are not normally eligible for unemployment? And that's all handled under Section 2102 of the CARES Act. And it applies to sole proprietors, independent contractors, gig workers, certain agricultural workers, LLC members, partnerships, and church employees. It's designed for people who are not usually eligible for state unemployment benefits because they're not contributing into the system, but who are able to work, available for work, and then they also have to certify to the unemployment agency that the reason why they are underemployed or unemployed is due to a specific COVID-19 related reason. And then there are a number of different factors that go through that, and I've listed them here in this presentation so that you can take them home and have them, but I am not going to run through them all. For your purposes, what you need to know is that if your unemployment or partial unemployment has anything whatsoever to do with COVID-19, you're probably going to receive the enhanced unemployment benefit under Section 2102, with the exceptions that if you have the ability to telework and you can get paid for that, then you're not going to be entitled to unemployment. So, my accountant, for instance, is doing all of his work for home, and he's a sole proprietor. He is not going to be eligible for unemployment as long as that work continues. The other exception is if you are receiving paid sick leave or other sort of sick leave while on leave. Those folks will not be entitled to unemployment benefits. And it might be helpful to understand the process there too. So when a person calls to apply for unemployment benefits, they can designate that they're unemployed or underemployed, but they're also going to be asked what their earnings are. And so once you report earnings, that's going to diminish any benefits that you may have otherwise been entitled to receive. And if you're receiving your normal pay, those benefits are going to be diminished right to zero. So let's assume you're eligible under 2102 for benefits. How much is that going to be? It will be your state unemployment benefit amount plus $600, and that's going to be a straight $600 without any sort of proration. I said it's $962 a week maximum because in Michigan, the maximum state unemployment benefit is $362. For most folks who are working full time, their benefits are somewhere between $250 and $362 per week. The way that the agency is going to calculate the benefits for the 2102 folks is it will either look at what you've contributed, if anything. If you haven't, it's going to look at your net income for 2019 as far as what I'm hearing right now. How long will those benefits last? It should be up to 39 weeks up until December 31st of this year. It will be retroactive. So if you are covered, then you could receive benefits retroactive to January 27th of 2020 assuming, again, that you were unemployed or underemployed already at that time. That additional $600 that you get under the Federal CARES Act may expire on July 31st. That's really sort of a legal argument that I'm sure none of you have any interest in hearing, but just so you have that on your radar, that might not be part of the benefit after July 31st. Another question we're getting is about what sort of enhanced benefits employees will be receiving under the new CARES Act, and that's all handled under Section 2104. Basically, under that section, if you have workers who are earning W-2 wages and they are unemployed, they will get an extra $600 per week. And importantly, critically, to a lot of employers who still want their employees to show up to work, is that $600 a week is not only on top of their state unemployment benefits, but it's not reduced based on their normal income. So if you have an employee who doesn't earn, particularly high wages, or basically if they earn less than, say, $700 a week, simply by going on unemployment, they're going to get a pay increase. So how can these lucky employees become eligible for 2104 benefits? Basically, they need to be eligible for state unemployment benefits, and they need not to be disqualified under state law. So to be eligible for benefits, for instance, they would not be receiving other pay. So if they were on a paid leave, as I mentioned before, with a 2102 benefit, they wouldn't be, they wouldn't have any eligibility to receive unemployment benefits because they're already getting paid. Employees can also be disqualified from receiving unemployment for various reasons, some of which have been suspended. But what has not been suspended is if there is work available for an employee and the employee is able to do it, then the employee does not have a right to unemployment benefits. Same if an employee was fired for some sort of misconduct, they would not be entitled to unemployment benefits. So as I mentioned, the state unemployment benefits would be the $600 a week on top of the state benefit, which is anywhere usually between $250 and $362 for a full-time employee. And those 2104 benefits will last until July 31st of 2020. Following those benefits, we then have the Section 2107 benefits. And those are basically the additional benefits that will kick in once people exhaust their 26 weeks of Michigan unemployment benefits. And those benefits, like the others, are going to be your state unemployment benefit plus the federal enhanced $600 a week. And those will last for an additional 13 weeks. A question that we've been receiving often is, when are people going to start getting these benefits? So the way this is supposed to work is that the state unemployment agencies are the ones that are going to be administering these programs and providing the benefits. Michigan entered into an agreement with the U.S. Department of Labor on March 30th, so our agreement is in place. The 2104 benefits are operational in the sense that employees can, start filing claims and should be paid for them. Those claims, I expect, will probably be paid within the next week or two, but it's not entirely clear given the, overwhelming number of claims that the unemployment agency is trying to process right now. For the 2102 folks, so those people who are not normally entitled to unemployment, there has been a notice on the unemployment agency's website for days now, basically saying that they aren't set up for it. So they are working on getting their system set up to process those claims, but they're not currently able to do that. I know that I know of at least one person who tried to file for 2102 benefits and did receive a call back from the unemployment agency saying that they weren't currently able to process it, but reminding them to keep trying. And that would be my advice to any of you too, is to keep checking that website. And if you've already tried to file for benefits, to follow up and keep applying. Another question we received is whether paid leave will impact enhanced unemployment. I think the answer is probably going to be yes, that it will be treated as earnings. But that is one of the things that is still not entirely clear. So with all of these enhanced benefits, including employees who can earn more by staying home than they could by going to work, one issue that a lot of employers of essential workers have had is, how on earth am I supposed to get people to come to work and do these jobs that are critical to either my company or, frankly, even sometimes to the nation as a whole? And there's a lot of, I wish I could tell you that there is a silver bullet for how to handle this, but there's not. All I can do is sort of walk you through some of the things we've tried to do to mitigate this problem. The first is communication, and Steve spoke to that a bit on the front end, but this is really an opportunity for you as a business owner to tell your workforce what they do, why what they do is so critical to this nation's infrastructure and the company, to clarify any misunderstandings that they might have about whether they truly qualify as an essential worker. I think that a lot of employees feel like they really aren't critical and their employer is just being greedy, and that's prompting them to report them to the Attorney General's office so that they don't have to come to work, and they feel like they've done some good. So it is important, as Steve mentioned on the front end, to try and clear up any misunderstandings about what that means and what their role is in this whole situation. It's also extremely important that you communicate to the employees about the things that you have done to make sure that the workplace is safe, including that you've complied with all of the CDC guidelines in terms of keeping employees at least 6 feet away from one another, additional sanitization and cleaning of the facilities and things like that, and that you're also complying with MIOSHA standards. If that doesn't work, then you are probably going to have to think about what you do next in terms of do we go down a discipline or discharge path or not? There are some obvious practical considerations to that. I mean, if before this all happened, it was very hard to find and retain employees. So you want to be able to keep your talent, assuming there's still jobs available after this. But it's also extremely important to make sure, particularly in certain businesses, to have folks at work. It sort of where you fall on that spectrum sort of depends on how critical it is to have those people at work. So, our healthcare clients, for instance, have been taking much more aggressive approaches on this than maybe some of our, manufacturing clients. From a legal perspective, too, you have to consider whether these employees are engaged in any sort of protected activity. I listed some of those. I don't really have time to go through all of them, but the one critical one that I wanted to mention is that there was an executive order that the governor issued on Friday, which basically states that employers cannot discipline or discharge an employee who either needs to stay at home in quarantine because they have symptoms of COVID-19, which were described as a fever, dry cough, or shortness of breath, or atypical cough or shortness of breath, or they have been diagnosed. It also prohibits an employer from discharging or disciplining an employee who has been in close contact for a prolonged period of time with someone who has symptoms of COVID-19 or has been diagnosed with COVID-19. And, there's a whole lot of additional factors that go along with that. But the bottom line is, if you discharge somebody under those circumstances, you may very well be in violation of that executive order. You also would likely be in violation of the Family First Coronavirus Response Act, because employees would likely be protected or entitled to leave under that act based on the executive order as well. So, under those circumstances, one of your options would be to, put the person on a paid or an unpaid leave of absence while this whole thing rides out. Another thing that you could talk to your employees about more generally is entitlement to benefits. So if you want to incentivize people to come to work, there are some healthcare plans that would require employees to be actively working, and that definition is going to vary based on your own healthcare plan. But looking forward into the future, if employees have major concerns about having healthcare coverage and remaining on healthcare coverage, that may be something that you can talk to them about as an incentive to return to work. Unemployment as well, as I mentioned earlier, typically refusal of available work is considered a voluntary quit, and employers should not be eligible for unemployment under those circumstances. I say in ordinary times because these are obviously extraordinary times where it seems that the governor's office is very interested in providing expansive unemployment benefits to employees. So I don't have a whole lot of confidence that even if we challenge claims for unemployment, that we'll win, or even that it'll happen anytime soon, because again, the agency is so overwhelmed with all of these claims that just the administrative burden of processing these challenges to unemployment may be overwhelming for the agency. One thing you could do is stress to employees that they may not be receiving benefits right away, again, because of all these issues. So with that, I'm going to turn to the Family First Coronavirus Response Act that was passed by Congress. Gosh, when was it? 2 weeks ago or so? Basically what that does is it creates mandatory paid leave under two new laws. One is called the Emergency Paid Sick Leave Act, and the other is basically an expansion of FMLA. For private sector employers, everybody who has fewer than 500 employees is covered. And of the employees that are covered for emergency paid sick leave, all employees are covered, regardless of how long they have worked for you. For the expanded FMLA eligibility, it would be employees who have worked for you for 30 days. So for instance, if an employee wanted to start taking leave on April 1st, if they have been working with you since March 2nd, they would be entitled to take that leave. The Department of Labor also clarified that for employees who've been laid off on or after March 1st, those employees would also be entitled to leave if they worked for 30 of the 60 days before the layoff. So, for instance, if an employee was laid off on March 1st and had worked for you from January 15th to February 20th, and then you went and hired that employee back again, that employee would be entitled to expanded FMLA. The expanded FMLA applies to both full-time and part-time employees. And basically what it does is for the employee paid sick leave is it enables employees to use the equivalent of 2 weeks of emergency paid sick leave, and that is on top of any other paid leave that you provide when they're unable to work or telework for 6 different reasons. The first is because of a federal, state, or local quarantine or isolation order that prevents them from working. One example of that would be the order that I referenced earlier that came out on Friday. That executive order is likely considered a quarantine order. The one caveat there is that in order for a shutdown order to qualify under this prong, it has to be the but-for reason why the employee can't work. So if there's a quarantine order that shut down your business and an employee can't work because of that, or because they're laid off for lack of work, they're not entitled to emergency paid sick leave. It's only for people who otherwise could work but cannot work because of some federal shutdown order or quarantine order. The second prong is employees who've been advised by a healthcare provider to self-quarantine due to COVID-19 concerns. And that applies to employees who are dealing with their own concerns. So, employee who has their own issue, not to care for somebody else. The third is an employee who is experiencing COVID-19 symptoms and is seeking a medical diagnosis. The fourth is for an employee who's caring for somebody, an individual under a quarantine or isolation order, or who has been advised to self-quarantine. The individual has to be someone with whom there's a personal relationship. So it can't be some stranger, but if it's a roommate or a family member or someone like that, they would be covered. Another reason why you'd be entitled to leave would be if the employee is caring for a son or daughter because the son or daughter's school has been closed or childcare is unavailable due to a COVID-19 related reason. And then the final is sort of a weird catch-all for, if the employee is experiencing any substantially similar conditions that are declared by Health and Human Services in conjunction with the Department of Treasury and Department of Labor. So what are employees entitled to under the Emergency Paid Sick Leave Act? Basically, for full-time employees, they're entitled to 80 hours of paid sick time. For part-time employees, they are entitled to the average number of hours that they would normally work over a 2-week period. So basically, the purpose is to give employees the equivalent of 2 weeks of paid leave. The calculation is going to be paid at the employee's regular rate for 2 weeks of that time. There are caps. So for the first 3 events, those self-care events where I'm quarantined or I'm experiencing symptoms, there is a cap of $511 per day and $5,110 total. For the other events, so for the caring for others events and then that catch-all, those are capped at $200 per day and $2,000 total. For expanded FMLA, eligible employees are allowed to use up to 12 weeks of expanded FMLA. 10 weeks of those are sorry, I lost you for a minute there. 10 weeks of those are paid when they cannot work or telework because the employee is caring for a son or daughter due to a school closure or unavailability of childcare. After the 2 weeks of FMLA are unpaid, the employer is responsible to pay out at the regular rate 2/3 of the employee's regular rate of pay for the hours they would typically work. There's a cap on that also at $200 a day and $10,000 total. You may have heard that there is an exemption for small businesses, and that is true to a certain extent. So for small businesses who have fewer than 50 employees, they may be exempt from the duty to provide either emergency paid sick leave or expanded FMLA if it would jeopardize the ongoing viability of their business to do so. And then I included a slide in here just with the specific criteria, but basically it's a fairly high standard for if it's truly going to cause you to shut down, then you would not have to pay that sick leave. Finally, just sort of the catch-all of what else do I have to do if you're covered under the FFCRA. There is a Department of Labor notice that they have prepared that you are obligated to either post on your work site or otherwise make available to employees, and I included a link here to where you can find that. Also, there's a specific obligation imposed that you not interfere with, discriminate, or retaliate against employees for exercising their rights under the FFCRA. And so with that, I'm going to open it up to questions.
All right, thank you. And we do have some questions. We'll start from the top here. So what if an employer is fairly new to having employees and is not yet paid into unemployment? Are his employees still eligible to draw?
I would expect so. Yeah, I would expect that they would be. I think there would just be an issue with, what the employer might owe down the road. But I would regardless encourage them to apply, because whether they are or they are not, I think the unemployment agency has been very generous about granting the benefits. But I expect that they would.
Okay. Somebody asks about a situation. They had an employee who went down to Florida. So when the employee got back, they asked the employer asked the employee to stay home for 2 weeks.
Mm-hmm.
So when that period is done, do they have to pay them for that 2 weeks? Is that unemployment? How do you count that 2 weeks if you have asked your employee to stay home because of some connection to Corona?
They would be eligible for unemployment. So if the employer is the one telling the employee you cannot come to work, then the employee is going to be able to designate that as being unemployed. The employer could, if they chose, offer to provide the employee, the employee could use paid sick leave or vacation or something like that. And in that event, the employee would not be entitled to unemployment because they're receiving other benefits.
Okay. We are getting a number of questions about the $600 in the CARES Act there. One specifically asking about employees who have seen their hours decreased. They're not laid off, but they've seen hours cut down to 1 day a week. What is the unemployment status for that?
So for those employees, they will get a reduced amount of unemployment based on being what we would call underemployed. And there's a specific calculations the unemployment agency uses to reach those numbers. But the bottom line is they will get the full $600 of enhanced federal unemployment plus a portion of the state unemployment benefit. So if you have somebody who's working 1 day a week, I expect that they would qualify as underemployed. So they might get an additional $80 or something on top of the $600.
And that $600.
And I'm totally making up that number, by the way.
Yeah, that $600 is for everybody, not just higher employees who had higher pay rates.
Yep, that's correct.
Everybody
The $600, everybody gets that. And that's really what is causing some headaches for employees of essential workers, because what happens is the federal government has essentially created a situation where it is financially beneficial for a lot of employees to not come to work.
Mm-hmm. There's one for Stephen here. Please clarify critical infrastructure versus essential services.
Sorry, is the question, is there a difference between those two?
Yeah, what is the difference between somebody being labeled as critical infrastructure versus essential services?
There is no difference. That's just a terminological distinction. The executive order specifically references critical infrastructure. So entities and workers that provide, that work in those particular sectors, in those spaces, they are critical infrastructure workers, and that is what is essential. The executive order includes stuff that is beyond just what's in the federal guidance. It also includes child care workers, et cetera. But it's for all intents and purposes, it's one and the same.
Okay, thank you. There is a question that actually hits home for me because I'm in a similar situation. My 17-year-old was laid off from his job. So are students and those with summer jobs eligible for unemployment?
Yes, if a person was employed and they have been laid off, then they would be eligible for unemployment. And one of the things that the agency did the executive orders did is they loosened a lot of the requirements that otherwise would be imposed on people for filing unemployment. So in terms of they basically, the agency is going to consider everyone to be looking for work and that work is unavailable. So yeah, they should definitely apply for unemployment.
And is there a distinction between full-time and part-time employees when it comes to getting these benefits?
Only with respect to how much benefits they would receive through unemployment. So both part-time and full-time employees can apply for unemployment, but their benefits would be different.
Okay. Are active owners of an S Corp normally eligible to receive unemployment benefits?
I do not believe so. I think they would likely be qualified under the Section 2102 of the CARES Act, but typically business owners aren't paying into the unemployment system and therefore would not be entitled to unemployment.
Here's a question from someone who says her business has 3 minority owners, 5, 10, and 25% shareholders. Can they draw unemployment?
I actually don't know the answer to that question. I mean, I think it would depend on, whether they meet the criteria of, under 2102 for, meaning that they're not otherwise eligible for unemployment. They are one of those people listed there. So members of an LLC, S corporation, sole proprietorship, those types of folks would be. Otherwise, I would think not. But as I shared with you, Troy, I actually have a partner who is the leader on all of the unemployment specific things. So when it comes to the really deep dive details, I would refer there.
Okay, we will try to get an answer to that one and get that over to you on that answer for the person who asked that. There's some questions that are more specific to unemployment and some of the issues we're seeing around the system being overwhelmed. So if a consumer has problems with a login, they can't get into their account, if they have questions about whether they filled out their stuff right, a lot of people are filing unemployment that have never filed before. What advice do you have, knowing that you probably can't get into that phone number very easily?
Well, as I mentioned earlier, I think the best advice I could give is to try and call at an off time. So, your best chance of getting through is if you're not doing it at 11 a.m. or noon. If you try and call, at an off time when other people may not be as where it might not be as busy, that's my best advice. The unemployment agency also does have a lot of Q&As, and they are trying to put up a lot of information on their website to sort of guide you through. Also, as I mentioned earlier, I think there have at least been some situations where we've heard the unemployment agency has reached back out to filers to clarify things or to ask questions and to provide some insight. So, I think that they're working hard and they're trying to get all of these claims processed. And they will be. I mean, it may take a little time, but I'm confident that people will end up getting their benefits.
And I can tell you from my own family's experience, anybody on here, you can get on a callback list. The estimate of the time is wildly off. We were told yesterday, 2 to 2.5 hours. That was yesterday, and we haven't heard back. But we're hopeful we'll hear back. So just be patient, I guess, is the advice.
Yeah, or keep calling, or don't be patient and keep calling. If you have enough patience to keep calling, I wouldn't hesitate to do that. I do worry that the agency is so overwhelmed that I know that there are the best intentions, and I think eventually all of these claims are going to get processed, but it's not inconceivable to me that things could slip through the cracks, and so I think you have to be your own advocate.
All right, so we've got some questions here about they fall under the label of critical infrastructure, but they have reduced activity based on the stay-at-home order. Most of their employees are laid off at this time. They can't bring everybody back due to lack of work. So how do they handle those employees that don't come back or don't want to come back at this point, even if they try?
So let me get this straight. Do they want to bring the employees back, or do they not want to bring the employees back? So
it sounds like they want to bring some back, but there are some employees who don't want to come back at this point.
Okay, so for employees that can come back, that we want to bring back, I think what we tell them is you want to clearly communicate in writing, we have work for you, and kind of going back to the communication piece, you're an essential worker. This is why what you do is critical to our nation's infrastructure and to this business. We have designated you a critical worker. And then, if you get pushback from them and they're telling you they're not going to come back, then you got to go down some of those other roads and think about, well, are we gonna discharge you, or are we going to tell them that we are going to contest their unemployment? Because if we have work available for you and we have a safe workplace here for you, and the employee hasn't engaged in any sort of protected activity, then we could certainly challenge their unemployment benefits. And so, this $968 or $962 that they're hopeful to receive might not come to fruition.
All right.
More likely they'll probably get it, and then we would contest it and try and have it clawed back.
Thank you. We have some questions about work share programs. How does that work with the unemployment situation we have?
That's actually one of the questions that I always refer to my partner.
Okay.
So I'd be happy to follow up on those, but.
Okay. We will work to get an answer to those as well. So one question that comes up is advice to a business they've got 10 days of sick pay. Employees calling in saying they have a fever. What other kind of substantiation should an employer be looking for when people call in sick in this environment?
That's a great question. So we have forms that we prepared, and I would encourage everyone to get their hands on some that basically require employees to provide the information that is allowable under the FFCRA, and that also is what we would need to have as an employer in order to obtain the federal tax credit. So for an employee who says they have a fever and they can't come into work, they have to be under FFCRA. They have to be both experiencing symptoms and they have to be seeking a medical diagnosis, right? So, you would need to have information about, the healthcare provider who you have to have the name of the healthcare provider with whom you have sought treatment, as well as your certification, that your own personal certification from the employee that they do in fact have that condition. But the forms should be able to walk you through all the things that the employees need to provide in terms of documentation.
And then we'll do one last question here. I know we're running short on time. We wanted to get this in an hour. If a company was approved for the PPP, that the stimulus plan from the SBA there, how do we take employees off unemployment and then pay them directly from the PPP funds?
You would recall them from unemployment. So you'd recall them to work. So you would say, we have, similar to the earlier question, send them a letter explaining what they do, why they're an essential worker, that you now have work for them to do or telework for them to do, and you bring them back. This is your start date, and then you bring them back on your payroll. Okay.
So Cathy and Steve, thank you so much for joining us. It's been valuable, critically valuable information for businesses here. We don't want to go over an hour too much. Everybody has a lot to do. Thank you so much. Any final comments you two might have? Steve, why don't we start with you?
Oh, thank you so much, Troy. It's really enjoyed being here, and obviously Cathy especially has quite a bit to offer in terms of assistance here. And I would just say, in terms of, we've talked a lot about documenting your decision making, making sure that you're transparent, you're able to communicate, and you're able to explain why you've made certain decisions. And that's certainly something that we've seen has been very, very helpful for our clients. And so I would just encourage everybody to think very carefully about documenting everything that they're doing.
Yeah, I echo that, both with the appreciation for having us here and also with, communication with your employees. I think that's critical for a whole host of reasons, both with respect to, maintaining a good morale through this very difficult time, as well as, protecting yourself from any claims that may arise related to any of these new laws or executive orders or those types of things. And then finally, for all of you to stay safe and healthy and sane during this very challenging time for everyone.
Thank you so much. Cathy, if you could move to that last slide there for us. All of these slides are going to be shared out. We're going to send out a video. This has been videoed of them. So we've got the entire webinar recorded. We will share this with everybody. It will also be up on our YouTube page. We are going to share these slides out. We're going to try to get answers to those questions that we weren't able to get answers to today. And we do have upcoming webinars from the Better Business Bureau for accredited businesses, getting the most out of your BB accreditation, taking some time to make sure you're getting your full benefits. That will be on Thursday from 1 to 2 o'clock. And we are in talks with the Small Business Administration to talk about their loan programs. They are constantly updating that. I was on the phone with them just yesterday morning. They are working to get the latest guidance on this, and as soon as they're ready, they want to make sure they're able to give everybody the right answers at once. So as soon as we get that, we will get that out. I know there's a lot of interest in that SBA webinar, and we will have that momentarily or as soon as we can. So thanks again for coming. I appreciate it. We will be sharing this out, and you have a fantastic day.